Recording in progress.
我已經插啲標佬，而嗰啲俾我插晒，難嗰啲要揾。係喎，都未得人追期。我要啊，係追問你。啊，遲啲有一個要聽日，我驚我唔記得，有一個標佬要你投佢啊。
Okay, I think we'll get started. We're bang on 6:45, and I'm conscious we've got a number of people online, so we thought it would be good to start straight away. My name is Simon Chapman. I'm a partner at Herbert Smith Freehills in Hong Kong, and I'm delighted to welcome you all here to the Mediation Lecture 2022, right in the middle of a legal week here in Hong Kong. It's particularly good to see so many people here in the room after years of this event being entirely online. And we also have more than 400 people joining us on the live stream. So a warm welcome to you all. Herbert Smith Freehills has been proud to sponsor this lecture since its inception 5 years ago, working in partnership with the Department of Justice. And we're particularly grateful to the Secretary for Justice and his team, who are all here with us this evening. This year obviously marks a very special year in Hong Kong with the 25th anniversary. And so we wanted to ensure that we had an extra special guest speaker here this evening. And I'm delighted to welcome the Honourable Mr. Justice Lam, who joins us tonight. I know that the Secretary for Justice was keen to say a few words of introduction, but I also just wanted to extend our welcome and to say how honoured we are to have you with us this evening. One small housekeeping point before I hand over. As this is a hybrid event, and to ensure that everybody participating both here in the room and online has an equal opportunity to ask questions, there is a survey for everybody to submit questions that they wish to raise. So for those of you in the room, you should find on your seats a QR code, which if you scan will take you straight to the survey portal where you can type in the questions that you would like to ask. For those who are joining us online, there is a link directly in the portal which will take you to the survey. So please do raise any questions that you have as we move through the lecture this evening, and we will endeavour to get through as many of them as we can do at the end of the lecture. My partner, Catherine Sanger, will be moderating a short Q&A at the end. So on that note, I wanted to hand over to the Secretary for Justice for his welcome and introduction to you. Thank you.
The Honourable Mr. Justice Lam, ladies and gentlemen, I only intend to say a few words because I'm very sure that you do not wish to hear from me. You wish to hear from Mr. Johnson Lam instead. Now, on behalf of the Department of Justice, it's with a great pleasure and indeed an honor for me to welcome our very distinguished guest, the Honorable Mr. Justice Lam, to speak to us today. Now, this year actually marked the 4th mediation lecture. And I also wish to thank Herbert Smith Freehills for sponsoring this series, which allow practitioners and all those who believe in mediation to gather and exchange views. Mr. Justice Lam does not need any introduction. I still recall that when we organized this event, there was some intense discussion internally as to who we should invite to be our guest speaker and on what topic. And the only person that came to my mind, and in fact, I insist that we must invite Mr. Johnson Lam. And I'm very, very pleased that Mr. Justice Lam accepted the invitation, and here we are. Now, Mr. Justice Lam has been a very staunch supporter of mediation. He has been visionary, a lot of vision, and he has done a lot of work in promoting the use of mediation in the judicial process, in particular in the family law area. And it is also my hope to bring mediation to the community as a whole. I'm sure that the judiciary and the Department of Justice will continue our efforts, our joint effort in fostering a mediation culture in society. Now, I know that Mr. Justice Lam has given a very insightful speech quite recently in July on mediator-assisted financial dispute resolution and child dispute resolution. And I certainly, like the rest of you, look forward to Mr. Justice Lam sharing today on court-annexed and court-based mediation schemes, in particular on the importance of two fundamental features in the mediation process, namely confidentiality and privilege. I do not waste any of time, so without further ado, may I invite Mr. Justice Lam.
Thank you, Secretary for Justice, for your introduction, and also thank you for giving me the honor of coming here this evening to share with you some of my thoughts about confidentiality and privilege in court-based and court-annexed mediations. I decided to take off my mask because I have been suffering from some coughing these days, and maybe I have to drink water from time to time, so please bear with me. But I'm glad that this lecture has received such a warm welcome. The topic tonight is confidentiality and privilege in court-annexed and court-based mediations. Going a bit back in terms of history, on 30th November 2007, conference Mediation in Hong Kong, the Way Forward, co-organized by some major stakeholders, was held at the Hong Kong International and Arbitration Center. Since then, with the impetus provided by that conference and also the work of the mediation team in the Department of Justice, coordinated by the Working Group on Mediation under the successive leaderships of various Secretaries for Justice, substantial progress has been made in the accreditation and regulation and promotion of use of mediation in Hong Kong. In its report published in 2010, the Working Group on Mediation identified confidentiality and privilege as two fundamental features of mediation. Three justifications for confidentiality were identified in that report. First, it makes mediation an attractive option to those who wish to avoid publicity and increase parties' willingness to mediate, since they know any disclosures made during mediation cannot be used against them subsequently. And second, confidentiality enhances the effectiveness of mediation by encouraging frank and open discussion between the parties of their real needs and interests, which in turn promote the settlement of the dispute. Third, confidentiality safeguards the integrity of the mediation process by excluding mediator from the pressure of making disclosure during or after the mediation process. After that, the Mediation Ordinance, Chapter 620, was enacted in 2013, pursuant to the recommendation of the working group. In today's lecture, we would examine how the common law and the Mediation Ordinance safeguard these fundamental features in court-annexed and court-based mediation schemes. I shall begin with a brief survey of our court-annexed and court-based mediation scheme. Then I shall examine the common law on confidentiality and privilege before I turn to the statutory protections under the Mediation Ordinance. Finally, I shall offer my views on how the law is applied to our court-annexed and court-based mediation schemes and make some suggestions as to how the common law may develop in the future. Now, let me start by going through or give an introduction of what we have been doing in our court-annexed and court-based mediation scheme. While previously, mediation has already been widely used in family and construction dispute, after 2008, it has been adopted by parties in other types of dispute at all levels of court. The judiciary has always been a firm supporter in the promotion of mediation. The Chief Justice Working Party on Mediation has introduced many mediation-related initiatives since its establishment in 2006. Over the years, we have also set up a number of court-annexed mediation schemes at various levels of court to facilitate the use of mediation by litigants. We have the Family Mediation Coordinator Office providing services to litigants in the family court by assisting them to understand the nature of mediation and providing them with information on family mediators. Pre-mediation consultations with the parties were conducted and assistance were given to them to set up appointments with private mediators. We also have the Building Management Mediation Coordinator's Office, BMMCO, at the Lands Tribunal, providing similar services to litigants in the building management disputes. We also have the Mediation Information Office at the High Court Building, provide similar services to litigants in other civil cases. Since April 2018, the Family Mediation Coordinator Office was merged with the Mediation Information Office to become the Integrated Mediation Office, IMO, at Wan Chai Tower, where the district court is situated. Under these, what I call the court-annexed mediation schemes, the staff in the IMO or the BMMCO introduce litigants to the concept of mediation and mediation services and provide pre-mediation consultation to them. But these staff do not conduct mediations. Information about mediators specialized in the types of dispute are available, and some of these mediators offer pro bono services. Litigants who are willing to undergo mediations after pre-mediation consultations could engage these independent mediators to have their mediations. Mediations will be conducted by the mediators outside court premises, and the IMO or the BMMCO has no involvement in the actual mediations. In 2018, another court-annexed mediation scheme commenced operation at the West Kowloon Mediation Center, which is situated on a piece of land adjoining the West Kowloon Law Courts, where the Small Claims Tribunal is sited. The scheme targets as serving litigant in the Small Claims Tribunal, and it was a pilot scheme administered by the Department of Justice. Its operation was undertaken by the Joint Mediation Helpline Office as an independent body. Though the pilot scheme was not run by the judiciary, it is still a court-annexed scheme because there was coordination between the tribunal and the center in terms of the system of referring cases by adjudicators to the scheme. The mediation services under the scheme were provided by mediators appointed by the center, which also offer venues for mediation to take place. The center provides supporting services including pre-mediation consultations. Based on statistics kept by the Department of Justice, 1,306 cases were referred by the tribunal to the center, and overall success rate was 55%. The experience with the scheme shows that there is a considerable demand for mediation services in the small claim tribunal, with referrals by adjudicators and the vicinity of the mediation center next to it, litigants in the tribunal in which there is no legal representation are willing to undergo mediation to resolve their disputes. The success rate also indicates that even though the impact of course on small claims dispute may not be as significant as that in other cases, there is still a substantial room for mediation to provide a satisfactory alternative to litigation. The pilot scheme ended in June 2022. In light of the positive outcomes in the scheme, the judiciary decided to set up the Integrated Mediation Office at West Kowloon, what is called IMO West Kowloon, which offers similar services at the same location. The adjudicators of the Small Claims Tribunal refer suitable cases to the IMO West Kowloon, and whilst mediation services would be provided by the staff of the IMO at West Kowloon, mediation would be conducted by private mediators who would provide their services on a pro bono basis. If parties are willing to mediate, mediation would take place at the IMO at West Kowloon. Looking ahead, the judiciary is considering expansion of the existing court-annexed mediation service in the family court by setting up a pilot scheme of duty mediator for simple family disputes in the family court, while supporting services would continue to be provided by the staff of the IMO. The actual mediation in suitable cases referred by the court would be conducted at the premises inside the court building by a duty mediator, who will be remunerated at a fixed hourly rate. If implemented, it would be another form of court-annexed mediation. So in the context of these court-annexed mediation schemes, issues on privilege and confidentiality may arise in respect of communications at different levels. There's communication between litigants and court staff at the IMO for the purpose of considering the use of mediation, particularly information gathered at pre-mediation consultations. B, there are communications between the court staff and the mediator. And C, communications between mediator and the parties during mediation at joint sessions. And D, communications between mediator and each party during mediation at separate sessions. This distinction between communication at joint sessions and communication at separate sessions have to be considered on different level, and I will go into that later. Apart from court-annexed mediations, the judiciary has also introduced other mechanisms in our court proceedings for alternative dispute resolution. Some procedures involve the participation of mediators with an element of mediation built into it. I shall refer to these mediations as court-based mediation, as distinguished from the court-annexed mediation discussed before. In family proceedings, financial dispute resolution, FDR, and children dispute resolution, CDR, are procedures introduced since 2003 and 2012. They are decided by family judges. In FDR, the process is evaluative, and it is without prejudice in nature. And if the case is not settled, the judge would not be further involved. On the other hand, a CDR judge acts as a conciliator, and he or she can continue to preside at the trial of a child-related matter if settlement is not achieved. In the case of LLC and LMWA in 2019, the Court of Appeal gave its blessing to a process called mediator assist, FDR, MFDR. The court saw the potential for synergy by having a mediator within the FDR. Instead of mediation and FDR as two discrete processes, MFDR is a model of a continuous alternative dispute resolution process running in parallel with litigation. The party should go through private mediation first. If the case is not settled at the mediation, they would take part in an MFDR with facilities inside the court building. For mediation to be continued after seeing the FDR judge, they can also go back to the FDR judge with the mediator repeatedly to seek the views of the judge in order to resolve some outstanding issues between them. The first MFDR took place in October 2019. It resulted in a full settlement agreement. The mediator who was engaged in that process is here with us today. I'm happy to say that we have recruited him into the judiciary. Since then, 22 MFDR have taken place, and the results have been very encouraging. Up to October 2022, settlement rate is 89%. The success of this model depends on the synergies stemming from different roles played by the FDR judge and the mediator. Communication between the judge and the mediator is necessary to enable the judge to give useful and effective indications on various matters, which a mediator could subsequently follow up with the parties. There have been attempts to adopt a similar model for CDR. There was one case I know in which MCDR resulted in settlement. However, as CDR is not presently conducted on a without prejudice basis, it justifiably gives rise to some concerns. In my view, MCDR would only be viable if the relevant practice direction is amended to provide for the parties consenting to such process being conducted on a without prejudice basis. For general civil litigation in the district court, there is a court-based alternative dispute resolution process in the form of case settlement conference, CSC. In 2018, the district court launched a pilot scheme engaging some lawyers with mediation experience to sit as masters presiding in case management hearings. Such hearings were devoted partly to without prejudice settlement discussions, in which the master would explore cost-benefit analysis and settlement options with the parties. The pilot scheme was refined and evolved in 2021 into CSC, conducted by a master. In a CSC, the entire hearing is conducted on without prejudice basis, and the presiding master would not be further involved in the case if it is not settled. At the CSC, the master does not conduct mediation with the parties. There is no separate sessions, and the master cannot discuss the case with a party in the absence of the other party. The CSC pilot scheme will be extended in 2023 with a further enhancement by adding the option of having a mediator participating in the CSC in similar fashion as in the MFDR. The option would only be adopted with the consent of the parties. And of course, they have to pay for it because they have to pay the mediator. The mediator-assisted case settlement conference, MCSC, would take place in a without prejudice setting using facilities in the court building. The mediation conducted in the context of a MCSC would be another form of court-based mediation. So in the context of a court-based mediation, issues on privilege and confidentiality may arise in respect of A, communications between the party and the court prior to the MFDR or the MCSC. B, communications between the parties and the mediator prior to the MFDR or MCSC. C, communication between mediator and the judicial officer prior to the MFDR or MCSC. D, communication between the parties and the court in the presence of the mediator during the MFDR or MCSE. E, communications between the parties and the mediator during mediation at joint sessions. And lastly, communication between the party and the mediator during the separate sessions. Now, I will turn to the law on privilege and confidentiality relating to mediation first by reference to the common law. Confidentiality and privilege are often discussed together to underscore their importance to the integrity of mediation. Nevertheless, whilst there are overlaps in applications, these two are different concepts. Mediation, as it is practiced in Hong Kong, engages both of them. Confidentiality arises from the relationship between the parties, either as contractual or equitable obligations. Such an obligation is usually provided for in the mediation agreement entered into by the mediating parties and the mediator before mediation begins. Even in the unlikely event of a mediation conducted without any written agreement, equity would impose obligations of confidence when the information is received in circumstances in which a reasonable person would regard as confidential. Mediation has always been promoted and practiced in Hong Kong as a confidential process. Under the Hong Kong Mediation Code, mediators are required to observe the duty of confidentiality as a matter of professional conduct. It also provides that any information disclosed in confidence to the mediator by one party should not be disclosed to the counterparty without permission. Mediation is invariably held in a confidential setting, with the mediator starts off by reiterating its confidential nature. Thus, all participants and the mediators undergo the process of mediation on the basis that they are bound by obligations of confidence. Even before the enactment of the mediation ordinance, Hong Kong courts has repeatedly emphasized the fundamental importance of confidentiality in mediation. In a mediation, confidentiality works at various levels. It operates between the parties themselves. At the same time, it also operates between the mediator vis-a-vis the mediating parties. It also operates between the mediator vis-a-vis each party in respect of the communications in the separate sessions. As such, the parties are prohibited from disclosing to any other person the communications in the course of the mediation. Likewise, mediators should not reveal anything discussed in the mediation unless permitted by all parties or compelled by the law to do so. Further, they should not disclose communications made in separate meetings except with the consent of the party concerned, and these obligations are enforceable by way of injunctive relief. But the duty of confidence is not absolute. Under the common law, the court may order disclosure of confidential information if such disclosure is necessary for the fair disposal of a case. In the English case of Pharmacist and Secretary of Justice for the Environment, Justice Ramsey refused a mediator's application to set aside a witness summons, as in that case, it was found to be in the interest of the administration of justice for the testimony of the mediator to be obtained in order to determine whether the mediated settlement agreement should be set aside due to economic duress. In Hong Kong, Madam Justice Au Yang, in the case of Chu Chung Mei and Lam Wai Dan, upheld the confidentiality of the communication between the parties by letter in the course of mediation and struck out a party's evidence exhibiting the letter in another set of proceedings. In that judgment, Her Ladyship adopted the approach in Pharmacist and held that the letter was not necessary for the fair disposal of the later proceedings. Privilege is a separate concept from confidentiality. There are mediations in which parties attend with lawyers, and communications between a party and his lawyers in private are protected by legal professional privilege. However, in today's lecture, I will focus on without prejudice privilege, which is more relevant with regard to the communications amongst the party and the mediator. The rules of without prejudice privilege are primarily about admissibility of evidence in legal proceedings based on public policy. Litigants are encouraged to settle their differences through negotiations, and they should be able to put their cards on the table without worrying that anything that is said in the course of such negotiation may be used to their prejudice in the course of proceedings. A further justification for the privilege is based on the express or implied agreement of the parties that communications in the course of the negotiation should not be admissible in evidence in subsequent proceedings. Mediation as practiced in Hong Kong is a without prejudice process, and such communications are protected by without prejudice privilege under common law. In the case of Flew and Borchert, Lord Hope explained the essence of the privilege as follows, and I quote, "The essence of it lies in the nature of the protection that is given to parties when they are attempting to negotiate a compromise. It is the ability to speak freely that indicates where the limits of rule should lie. Far from being mechanistic, the rule is generous in its application. It recognizes that unseen dangers may lurk behind things said and written during this period, and it removes the inhibiting effect that this may have in the interests of promoting attempts to achieve a settlement." Previously, there had been debate as to whether the privilege was limited to prevent the use of anything said in negotiations as evidence of expressed or implied admissions against the interests of the party making the statement. The difficulty with such restrictive approach was highlighted by Lord Justice Robert Walker in the Unilever and Procter and Gamble case. And I quote, His Lordship said, "To dissect out identifiable admissions and withhold protection from the rest of without prejudice communication would not only create huge practical difficulties, but would be contrary to the underlying objective of giving protection to the parties. In the words of Lord Griffith in Rush and Tompkins, to speak freely about all issues in the litigation, both factual and legal, when seeking compromise, and for the purpose of establishing a basis of compromise, omitting certain facts. Parties cannot speak freely at a without prejudice meeting if they must constantly monitor every sentence with lawyers or patent agents sitting at their shoulders as binders." The House of Lords in Flew and Borchert by majority rejected the restrictive approach and endorsed the observations and Unilever. The approach of the majority in Flew was subsequently followed by a 7-member Supreme Court in the case Ocean Bulk Shipping and TNT Limited. In a Hong Kong case, Chu, Chongming, and Lam, Madam Justice Aoyang followed Flew and held that without prejudice privilege extends not only to admissions, but also to communication during the whole course of negotiations. Over the years, the courts have developed several exceptions to the inadmissibility of without prejudice communication. In Unilever, Lord Justice Robert Walker set out 8 exceptions. Because of the constraint of time, I will not go through these exceptions. I've set out some more commonly encountered exceptions in my written speech, which will be uploaded to various websites after today. But I want to highlight a particular exception which may have some bearing in our consideration of the mediation ordinance. The exception is what has been called conciliation privilege in family proceedings. and that has been developed. And in the case of Reed, a minor, in which Sir Thomas Bingham, the Master of the Rolls, alluded to the strong public interest in excluding statements made in conciliation from evidence. But this exclusionary rule itself is subject to a narrow exception, where a statement clearly indicated that the maker has in the past caused serious harm to the well-being of a child or is likely to cause such harm in the future. That would be an exception. But even then, it was stressed that the court should only admit the evidence if the public interest in protecting the interests of the child outweighs the public interest in preserving confidentiality of attempted conciliation. And similar approach have been adopted in a number of family mediations. There are other exceptions, and exceptions have been continued to be developed in the 2009. There is the case of ocean bulk shipping, in which Lord Clark identified other exceptions. While the vitality of the common law could provide further refinements of the rule, and new exceptions may have to be coined to meet new challenges, the salutary observations of Lord Roger in the case of Ofulu should always be borne in mind in developing these exceptions. And I quote from his lordship: "The question is whether creating such exception would be consistent with the overall policy behind the rule." In 2009, in two-part articles written by Justice Briggs in the New Law Journal, his lordship suggested that the common law protections were inadequate to fulfill the requirement of the EU Directive on Mediation, which provided that mediators must not be compellable to give evidence regarding information arising out of or in connection with a mediation, except where overriding considerations of public policy otherwise required, or where disclosure is necessary in order to implement or enforce a mediation settlement agreement. In particular, his lordship highlighted the importance of confidential communication between a mediator and a party in a separate session, which his lordship called mediator's secrets. And I quote, "The ability of a mediator to receive mediation secrets from the opposing parties without communicating them across the divide, and to use the knowledge thereby gained in assisting the party towards a settlement is unique to mediation as a dispute resolution process, and an important part of its success today." And end of quote. His lordship suggests that the public policy underlying legal professional privilege is similarly engaged in respect of such communications, and the common law could develop a mediator secrets privilege. However, such development appears to have been foreclosed by Justice Ramsey in the pharmacist case. Having considered the submissions of the parties that the court should recognize a mediation privilege, the learned judge reached the conclusion as follows, and I quote, "However, in mediation where existing concepts of legal advice privilege, litigation privilege, and without prejudice privilege can be applied, I considered that those principles provide sufficient guidance." His lordship also referred to a further privilege, but that was not what Justice Briggs had in mind. Instead, Justice Ramsey confined himself to the preservation of other existing privilege, notwithstanding disclosure to a mediator. Since then, judges generally analyzed privilege in the mediation context by reference to the without prejudice privilege. For my part, I can see the distinction made by Justice Briggs regarding mediator secrets in separate sessions and the communications in the presence of all the participants in joint sessions. but it would be difficult to envisage the court ordering disclosure of mediators' secrets, even on existing common law principles. So there were instances where mediators failed in their attempt to set aside witness summonses because of the exception to the without prejudice rule. They were usually called to give evidence about what had happened at the joint sessions. I am not aware of any authority holding that a mediator could be questioned in the witness box about what had happened at the separate sessions. It is practically quite difficult to demonstrate that on top of the disclosure of communications at the joint sessions, disclosure of the mediator's secrets is necessary for the fair disposal of a claim, particularly when the applicant for disclosure was not privy to what had happened at the separate sessions between the mediator and the other party. It is unlikely that the court would override the confidentiality and privilege attaching to mediator secrets based on the speculation of an applicant that it may contain some evidence helpful to his case. But in Hong Kong, as I shall discuss below, the matter should be governed by the mediation ordinance. And the ordinance, as I shall demonstrate, provide sufficient safeguards. The Mediation Ordinance, Chapter 620, set out in its preamble, is aimed at providing a regulatory framework governing the conduct of mediation in Hong Kong. Stipulated in Section 3B, an object of the ordinance is to protect the confidential nature of mediation communications. Section 8 prohibits a person from disclosing mediation communication with exceptions specified under subsection 2 and 3. Section 8, subsection 2 sets out the situations where disclosure can be made without the leave of the court, including those made with the consent of the parties and the mediator, disclosure of information lawfully in the public domain, disclosure under a discovery obligation in civil proceedings, disclosure for research, evaluation, or educational purposes, disclosure for seeking legal advice, and disclosure in accordance with a legal requirement. Notably, Section 8, subsection 2D permits disclosure when there are reasonable grounds to believe that the disclosure is necessary to prevent or minimize the danger of injury to a person or of serious harm to the well-being of a child. This exception was developed from the Reedy line of cases on conciliation privilege, but it is wider in scope because it covers danger of injury to an adult as well as serious harm to a child. Section 8, subsection 3 provides for the disclosure with the leave of court for the purpose of enforcing or challenging a mediated settlement agreement and for the purpose of complaint of professional misconduct against mediator. This is on par with the exceptions in the common law. There is also a residual open-ended power for leave to be granted for other justifiable purpose in the circumstances of the case. Without actually using the terminology of privilege, the admissibility of mediation communications in evidence is governed by sections 9 and 10. In determining whether to admit the evidence on without prejudice negotiations, the court should have regard to the possibility of disclosure under Section 8, subsection 2, and also the public interest and the interests of the administration of justice and other circumstances the court considers relevant. Other than a case where Section 8, subsection D is engaged, it is unlikely that a mediator would unilaterally agree to disclose mediator's secrets. For the reasons I've already canvassed, it is unlikely that a party who was not privy to the communication in a separate session could successfully apply for leave for such communication to be disclosed or be admitted as evidence. Now, I turn to how the mediation ordinance is to be applied to court-annexed and court-based mediations. From the contents of the ordinance, its provisions of general application in respect of all mediations conducted in Hong Kong. Mediation is defined in Section 4, subsection 1, and I quote, "It is a structured process comprising one or more sessions in which one or more impartial individuals, without adjudicating a dispute or any aspect of it, assist the parties to the dispute to do any or all of the following. A, they identify the issues in the dispute. B, to explore and generate options. C, communicate with one another. D, reach an agreement regarding the resolution of the whole or part of the dispute. It is any one of these four objectives would be sufficient as far as the definition of Section 4 is concerned. And this is a very wide definition. Potentially, it encompasses any structured, non-adjudicative process presided by a neutral, assisting the parties to achieve any one of the four objectives. The neutral actually needs not be a person practiced directly as a mediator. It could be a staff of the IMO or a judicial officer who, as an impartial person, take part in the structured process. The definition of mediator in Section 2(1) actually refer back to Section 4 for definition of mediator. Mediation communication is also defined widely in Section 2, subsection 1 as A, anything said or done, B, any document prepared, or C, any information provided for the purpose of or in the course of mediation. And adopting a purposive interpretation, case management hearing before a master, in which actually issues would be identified, should be excluded from this definition of mediation on the ground that such case management hearing serve the ultimate purpose of the adjudicative process and is therefore an integral part of it. So it does not come within the meaning of non-adjudicative process. However, given the courts are now more proactive in facilitating settlement of disputes with hearings like FDR, CDR, and CSC, specifically designed for non-adjudicative process, such hearings are arguably within the scope of that definition. And in this connection, Section 5, subsection 2 of the Mediation Ordinance provides for the disapplication of the ordinance to various processes set out in Schedule 1 to the ordinance. The processes specified in that schedule include conciliations conducted by public officers or mediations conducted by mediators appointed by public officers. The statutory arrangement therefore indicates that such process could be within the meaning of definition in Section 4, and thus, but for its disapplication under Schedule 1, the provisions of the Mediation Ordinance are applicable to them. Given that FDR, CDR, or CSC, together with MFDR, CDR, or MCSC, are not included currently in the Schedule 1, it is arguable that they are governed by provisions in the Mediation Ordinance. Should court-annexed or court-based mediation scheme be excluded from the ordinance by adding them to Schedule 1? In my view, it is desirable that the conduct of mediations, including pre-mediation consultations at the IMO, BMMCO, and the IMO as Kowloon, under the court-annexed and court-based mediation schemes be governed by the Mediation Ordinance. Mediators, lawyers, and parties need certainty as to confidentiality and privilege, protecting the integrity of the mediation process. The legislative intent behind the enactment of the Mediation Ordinance, as set out in the 2010 report of the working group, was to avoid the need to refer to case law to determine the limits of confidentiality and privilege. Instead, it was intended that the ordinance should provide a general statutory mediation privilege subject to those specified exceptions set out in the ordinance. I cannot see any justification for excluding mediations conducted under court-annexed or court-based schemes from such rationale. Thus, a mediation conducted by a mediator in an MFDR, MCDR, or MCSE should be governed by the mediation ordinance. Likewise, mediations conducted under referrals from the IMO, EMMCO, and the West Kowloon IMO should also be governed by the ordinance. I mentioned pre-mediation consultations conducted by the staff of the IMO, EMMCO, and the West Kowloon IMO, because Section 4, subsection 2A of the ordinance defines a mediation session to include not only the actual mediation attended by all parties and the mediators, but also any activity undertaken in respect of arranging or preparing for mediation, whether mediation takes place or not. So in other words, even if a party attending the IMO finally decide not to go for mediation, what has happened before as between him and the staff of the IMO should also be protected by confidentiality and privilege. And it is only so that the process or the integrity of the process is safeguarded. Same analysis could be applied to hearings presided by judicial officers assisted by mediators in MFDR and MCSC. It would be confusing to the parties and mediators if such hearings and the private communications between the mediator and judicial officers were to be governed by the common law, whilst the mediation component of that process is governed by the mediation ordinance. On the other hand, I think the conventional form of FDR, CDR, or CSC, that is without the mediation component, should be excluded from the application of the mediation ordinance. This can be achieved by amending Schedule 1 suitably. I hope such will not be cause any reservation on my part as to the confidentiality and privilege of these processes. The practice directions and guidance note on FDR and CSC have already provided explicitly that these processes are confidential and without prejudice in nature. In the case of AB against MAW, the Court of Appeal reiterated the importance of upholding such confidentiality. My reason for excluding them from the mediation ordinance stems from two other sections of the mediation ordinance, that is Section 7, which enable assistance and support to a party in the course of a mediation to be provided by non-lawyers. And Section 7A permits third-party funding in mediation for disputes undergoing arbitration. I think these exemptions are not appropriate for FDR or CSC. In its current form, CDR itself is not a without prejudice process. According to my understanding, judge hearing a CDR may subsequently preside at the trial, and therefore they would not go very far in expressing their views on the merits in CDR. As such, CDR could be regarded as a preliminary hearing to the trial and falling outside the meaning of non-adjudicative process as mediation under the ordinance. However, to avoid any uncertainty, it is better to add CDR to Schedule 1. However, in the future, if without prejudice MCDR were to be introduced, it should be governed by the mediation ordinance, subject to the disapplication of Section 7 and Section 7A. Now, I turn to the question whether the mediation ordinance now govern these court-annexed or court-based mediation exclusively, that is, to the exclusion of the common law. As discussed earlier, text of the mediation ordinance as well as the legislative intent show that the ordinance is meant to be the law governing the conduct of mediation in Hong Kong. The only exceptions are processes excluded under Schedule 1, it would frustrate the legislative intent if one still needs to resort to common law protection in the context of mediation. It is also clear from the above survey of the position under the common law that under the ordinance, the protection provided under Section 8 to 10 of the ordinance is no less than those offered by the common law. In these circumstances, there is no need for the common law in Hong Kong to develop a new mediation privilege. In short, we already had it under the ordinance. Having said so, the common law still continue to remain relevant because it will continue to govern other negotiation process which is outside the scope of the ordinance. Moreover, such development would remain germane in the actual application of the statutory regime because under Section 8(10), there are powers given to the court which are open-ended in terms of granting of leave for disclosure and admission of evidence in order to achieve a just result. As observed in the case of Crane World and Horntrade Engineering, public interest and the interest of the administration of justice underpinning the common law without prejudice privilege equally underpins the statutory mediation privilege. Hence, the court should pay regard to the public policy considerations discussed in the context of the common law in an application under Section 10 of the mediation ordinance. In short, the law must be administered coherently. Coming back to the different levels at which issues of confidentiality and privilege may arise in court-annexed and court-based mediation, they should all be subject to the rules set out in Section 8 to 10 of the mediation ordinance. Thus, in a court-annexed mediation, communications between mediators and the parties at the mediation, whether in joint or in separate sessions, are confidential and privileged. Likewise, communications between litigants and the court staff at the IMO or similar offices for purpose of considering the use of mediation are also protected, as they come within the definition of mediation communications under the ordinance. Communications between IMO staff and mediators are also information provided for the purpose of mediation and thus falling within such definitions. They are protected accordingly. By the same token, in the context of court-based mediation, communications between mediators and the parties prior to in the mediation under a MFDR or MCSC are obviously protected. Since the process itself, MFDR or MCSC, falls within the meaning of mediation under Section 4, subsection 1, with the judicial officer and the mediator playing the roles of neutrals as impartial individuals participating in the structured non-adjudicative process. All communications between the parties and the court prior to and during the MFDR or MCSC, insofar as they are made for the purpose of or in the course of the process, are mediation communications and would be protected under Section 8 to 10. Communication between mediators and judicial officers prior to the MFDR or MCSC are actually akin to communications between co-mediators and should be similarly protected as they are made for the purpose of MFDR or MCSC. So that's the analysis under the mediation ordinance. But for the sake of completeness, I would offer an alternative analysis on the assumption that, contrary to my primary view, court-annexed or court-based mediation schemes are governed by common law instead of the mediation ordinance. The different stages in these processes, in my view, should be considered as one single continuous without prejudice process, within which the staff at the IMO and the mediators and the judicial officer presiding in the process performing their respective roles and functions to assist the parties to reach a settlement. Viewed in this light, consultation at the IMO mediation sessions, and MFDR, MCSE hearing should all be regarded as different constituents of a single process in the application of the common law principles of confidentiality and privilege. Therefore, and I think they should therefore be subject to a uniform cloak of privilege. The pre-mediation consultations in IMOs and the MFDR and MCSE hearings are conducted in confidential settings with a view to facilitate mediations. The dominant, if not the sole purpose of these communications is to prepare for mediation. They should be regarded as part of the process of mediation. Rationale behind the public policy granting a cloak of privilege in respect of mediation is equally applicable to these communications. So, if necessary, the common law in Hong Kong should develop in a manner consistent with the policy underlying the extensive coverage protection of mediation communications under the mediation ordinance. The laws in Hong Kong provide robust support for the safeguard of confidentiality and privilege in mediation. Whilst it is beyond the scope of today's lecture to examine how Article 30 of the Basic Law can be relied upon to safeguard the privacy of communication, it should be noted that such right is engaged in respect of confidentiality and privilege in mediation communications. At the same time, the exceptions provided for in the mediation ordinance and the common law strike a necessary as well as fair and proportionate balance between such right and other legitimate competing interests. With an adequate legal framework in place, the judiciary has been working in concerted efforts with those in the legal and mediation communities under our court-annexed and court-based mediation scheme to cater for the needs of litigants. I would like to take this opportunity to thank those providing pro bono mediation services under the schemes. There are new initiatives for greater and better use of mediation in the pipeline, and I trust the judiciary can count on the continued support from the Secretary for Justice, legal profession, mediation community, and other stakeholders in the society in our efforts to further the development of mediations in Hong Kong as part of the continuing enhancement of Hong Kong as an international dispute resolution hub. And with this, I'd like to thank you for your patience.
Thank you, Mr. Lam. I'm going to take my mask off too. I don't have a cough, but I had a mediation lecture haircut today, so let's see it in its full glory. There are two questions before I give my closing remarks and to say thank you. The first question, the technology is actually very super because they've been printed out very quickly. What incentives may be provided to mediating parties in order to promote and encourage the use of these court-based and court-annexed mediations? I'll step aside.
Actually, the experience with the West Kowloon Mediation Center teaches us a lot in terms of what would be regarded by the parties as incentives. Firstly, under that scheme, mediation services were provided by a mediator in the vicinity of the court building. So actually people go there and at the same time they can go to have these services. So that by itself can be a very strong incentive. And that is the reason why we consider it may be a good thing. We have something like a duty mediator scheme, like a duty lawyer scheme in some of the court. I think for family cases, that definitely has a need for that kind of scheme. Another incentive is of course, the services are provided under the West Kowloon scheme free to the parties. But of course, this is a matter of funding, and also sometimes the balance has to be struck whether we always depend on pro bono services or whether the parties are required to pay some kind of fees. Then this is the kind of direction that we are thinking. Another incentive or rather motivation is the court roles in the referral, because when a party came before the court, the judge or whoever was handling the matter at that time can tell the party how mediation can assist them. And for many of these litigants, they will find it very enlightening, and sometimes they tend to take the advice of the court, particularly when it is so convenient to them. You just go to next door and then you can arrange all these. If it is a duty mediator, or even you can do it at the same time. So that saves them repeated trips to different parts of the venue to undergo mediation. Also, if the court have venue for this mediation to take place without a charge, that already is another kind of incentive. So on the whole, that's why I say we learn a lot from the West Kowloon experience. I am happy to say, and indeed the experience tells us that this is the kind of direction we should be going.
Thank you. Well, one more question, don't sit down. I think we just have time for the second question. And as a judge, I mean, it is sorry, I need to go to the mic to ask a question. So, as a judge, does the fact that the mediation, when we talk about court-based and court-annexed mediation, do you think that sort of hinders the sort of voluntary nature of that process? And if not, what can be done to enhance that? Thank you.
When one talks about the voluntary nature of the process, I often say have this idea. The point is, even if you undergo a mediation, whether you feel being compelled to do so or otherwise, it's still up to you to whether to agree to a settlement. Mediator cannot force you to go into a settlement. So by its nature, it must be voluntary or consensual in terms of the end result. But of course, you can say, well, if the court tells you better go to mediation, would you feel being compelled to do so? I think our judges would not say you must go to mediation. And also, another thing is, as I've mentioned in the lecture, that there is the intermediary of the information office. The litigant did not go directly to the mediator, they go to the information office first. So there is a cooling off kind of moment for them. They can still consider whether to use it. Of course, our information officer will be very helpful, and they always tell them what sort of benefits you can derive from mediation, but they would not force them to go to mediation. I think our mediation officer can tell that there are many people who go to the office but did not go to mediation. Moreover, I have this thinking that is, although at the beginning of the introduction of mediation to Hong Kong, the court or judges did take some leading role in the promotion. I think it would be much more helpful and effective if it is to be a parties-driven process rather than court-driven process. So the emphasis I want to play on is that actually lawyers or even those advising the parties, they can actively consider mediations on MFDR, MCSC with the parties, explore that possibilities. And if it is the parties who see the benefit of it and have the sincerity of using that mechanism to settle the matter, it would be much more effective than just going there to satisfy the requirement of the court to take the box so that we can tell the master that, we have undergone mediation. That's not our intention. We hope to provide this mechanism so that we can facilitate and have an option for the party, and they can use it to their own advantage.
Thank you, Mr. Lam. I'll just give us some very short closing remarks. I think it's a sign of a very effective and successful lecture when the remarks I thought about this afternoon that I might say, I've just torn them up mentally in my mind, a bit like a good mediation when you come out with a very different view of the world than perhaps when you go in. The first thing that struck me was this concept of CDR, child dispute resolution. I feel like I engage with that almost every day with my own children. And I like this prospect of having an M-CDR. So I hereby give my consent to having everything on a without prejudice basis, so long as I have access to all the mediators' secrets. But on a more serious note, I think looking at these protections of without prejudice and confidentiality, obviously very important. I think it's a reminder for us, particularly as practitioners, it called to mind also the use of when you want to be able to make use of without prejudice communications, and this concept of without prejudice save as to costs. And that's something I've seen. I did look up when I did look at some of these cases that were referred to. I got a sort of half an hour preview of the slides and how judges shut out any form of without prejudice communications, often even in a cost scenario, if you don't have that the save as to cost prefix. And I had a case before I joined HSF. It was a case I think that really led me to join the team here, where I lost, I wasn't the partner, but we lost against Simon Chapman, KC and Co. On the merits, but were very successful on costs because of the use of without prejudice save as to costs communications. And so that partly, it saved my job for the time being and then led me to join the team here. And I think it's a reminder, while I was sitting here, I have two cases that have been keeping me very busy this year that have settled. One case, the settlement agreement was signed as I sat and listened to the lecture. And another case is settling at the end of the week. And actually here at HSF, after most of our cases go to arbitration hearing, usually successful. So it's actually quite unusual to have two cases settling in short order. Now, one case was driven by lawyers pushing the settlement, but the other case was really driven by the clients. And in that case, it's a reminder that we as practitioners need to think proactively about how do we run cases efficiently and using greater form of ADR and mediation. And I think it's fair to say here in Asia, we don't use mediation as much as perhaps our contemporaries do in London, particularly, and the US. And it's something we did flag, and precisely that point was, why would we pay someone to be a mediator? And in fact, in that case, we had a client who effectively went in as mediator, and we've just achieved a very good settlement. But it's a sign, because through this settlement, this was very strong on the merits actually, but through the settlement, our client has managed to obtain something that they would not have got through the arbitration process. And I think that's a very clear reminder. In every case where I've done a mediation, I had a defamation mediation a few years ago, where we didn't achieve a settlement during the mediation, but we achieved a settlement shortly thereafter, which is often what happens. You get the parties together, and all that the other side wanted was an apology. And that was something that I pointed out. You can't get an apology through the litigation. So if you want an apology, then you have to settle it in some form of process. So I think it's a good reminder. So I'm going to add a prefix M, another acronym M-HSF, as we promote the use of mediation. I'm delighted to be here. This is number 4. I'm looking forward to seeing you all at number 5. It's really nice to see everyone in this room. I think this is the first big event that we've had for a number of years, and I have mask off, so that's nice standing here with suitable social distancing. Thank you, Mr. Johnson-Lamb. That was a really fantastic lecture, and I know there's a lot of work's gone behind the scenes, and to the DOJ who've run this like a very slick show as always. Anyway, have a good evening, and look forward to seeing you next time. Yes, exactly.